My name on the order paper.
Minister Banner-Scott of Braybrooke.
My Lords, children with learning disabilities may not have the mental capacity to manage their finances and may need someone to do this on their behalf. Parents need legal authority to access funds on their adult children's behalf and may need to apply to the Court of Protection. This is an important protection set out in the Mental Capacity Act 2005, and the Government is taking steps to improve the support available to parents in this position.
Lord Young of Cookham.
My Lords, last March the Telegraph drew attention to the problems facing 150,000 children with child trust funds who can't access their cash when they're 18 because of their disability, and whose parents have to go to the Court of Protection, a cumbersome and time-consuming process involving 47 forms and 100 questions. Will the working group that was announced yesterday by the Minister look at the alternative system of appointees used by the Department of Work and Pensions to pay exactly the same group of children, which is far quicker, far simpler and far cheaper?
I think the Noble Lord brings forth a very interesting point here. And I do know that the Ministry of Justice are looking and are working on this. And I've just heard that the DWP are in fact joining the working group. But, my Lords, the DWP appointees procedure does not extend to property and assets of the individual. It deals solely with government benefits. And extending the appointee scheme to child trust funds would not be appropriate as it is at the moment, as it would not provide the protections currently delivered by the Mental Capacity Act.
Lord Bishop of Carlisle.
My Lords, would the Noble Lady the Minister agree that some children with learning disabilities who are wanting to access trust funds may have life-limiting conditions, so that there may not be much time available for legal processes to be gone through? And can she assure the House that if such situations have not already been considered, they will be given the attention they deserve?
It is be given the attention it deserves, but there are already procedures in place that if a young person does have a life-limiting condition, then that issue can be dealt with almost immediately by the courts.
Browning.
My noble friend, Lord Young of Cookham, has identified what is actually a larger problem. I took all stages of the Mental Capacity Act through another place and also did the post-led scrutiny in our house. And I say to my noble friend, and I declare an interest, that for parents of both children with learning disabilities and many on the autism spectrum that resort purely to the Court of Protection or to expensive legal trusts is really no help to parents of limited means who try to provide for their children throughout their lifetime. I do hope my noble friend will consider that more is needed to look at the situation we now have, particularly with more people living independently.
I thank my noble friend, and yes, she's absolutely right, and that is why the government made the announcements yesterday that we do want to reduce the obstacles faced in supporting young people who lack mental capacity. And there are other things that can be done instead of the Court of Protection. If the young person does have mental capacity to have an involvement, then there, of course, is the much cheaper and much easier way of lasting powers of attorney.
Lord Singh of Wimbledon.
My Lords, on this National Day for Disability, it's particularly important that registered contacts and carers are helped to access child trust funds to meet the increasing needs of children with disabilities turning 18. Would the Noble Lord the Minister agree that while speedier permission from the Court of Protection is desirable, it's also in the interests of the child to ensure that enduring powers of attorney are still sufficient and fit for purpose to prevent possible misuse of funds?
Yes, I agree with my noble lord. It is important. This is a balance. This is a balance between making sure that those young people that do not have the mental capacity to access the funds get that easily, quickly and without cost, and that is what the government is looking at. But there are other ways, as my noble lord says, of lasting towers of attorney, where the young person can have an involvement in what happens to their finances.
Lord Blunkett.
I had the privilege 20 years ago of initiating the research and then working with the Chancellor of the Exchequer to set up the Child Trust Fund. We never envisaged at that time that this situation would have arisen, and I just want to reinforce the suggestions made by Lord Young, as usual, very sensible, in terms of trying to fast-track this and to ensure that the two big providers who are trying to find a way through are supported and enabled rather than obstacles put in their way.
I absolutely agree, but we have been doing, as I've said, that we are trying to reduce through a working party of people working on how to reduce the obstacles that the families are facing. But there's also a fee remission which will ensure that families who need to go to the Court of Protection to access these funds will not suffer financially as a result. And also, if they have already paid out finances, they can get that reimbursed. And that's now that there is this working group looking further at how we can improve the process.
Lord Addington.
My Lords, is it not something where the House should once again congratulate the noble Lord Young and pointing out an absurdity here? Will the government give us an undertaking that if they cannot find an ad hoc solution quickly, that they will find that little bit of parliamentary time that is needed to make sure we have a workable solution to this?
I'm not going to make a promise on that of extra time, but what I can tell you is that the working group have now been put together between the MOJ, between the Treasury, between DWP, the charities and the Court of Protection to make sure that, as I say, any of the accessibility issues are sorted out, but also that it is a much more streamlined process and it is not costing the parents any money.
Ms. Altman.
My Lords, I am delighted that the Government has established a working party and congratulate them also on the decision about the fee remission. But with the numbers involved here, it could be that there will be 25,000 court cases a year on this particular issue over the next 8 years or so, with COVID delays and capacity issues at court. And given that these parents are trusted by the Department for Work and Pensions to manage their child's benefits, would it not make sense to ask the Department to take seriously the issue mentioned by my noble friend Lord Young of Cookham, to use an established procedure?
We will absolutely and are looking at Lord Young of Cookham's ideas. And as I say, DWP have just joined the working party and we will work on that. That working party is starting straight away and will be reporting back to the Minister in early January. So we are not stopping on that. We're looking at the best way of dealing with these issues.
Lord Toohey.
My Lords, being disabled in Britain should not mean being a second-class citizen. But that is how it must seem for children with learning disabilities whose families face an expensive battle to gain access to the Child Trust Fund. Imagine, my Lords, the outcome if big city investors, or pensioners perhaps, were denied access to their own money. The government would be rushing to their aid. The Prime Minister has pledged to level up. So will the Minister tell him, these children should have access to their money now? The message is simple. Get this done.
I'm afraid, as I've said before, we are doing everything we possibly can. It is not costly any longer. The fee remission will ensure that families can go to the Court of Protection and will not suffer financially, and we get it done. We will get it done. But, my Lords, we have to take into account the Mental Capacity Act of 2005 and the fact that these young people are vulnerable at times and need protection through that act.
Lawrence Gardner of Parks.
My Lords, more than 700,000 teenagers will be given the keys to their child trust funds over the next 12 months. It was never made clear to parents that disabled children would be unable to access the funds at 18 due to their lack of mental capacity. And an application to the Court of Protection on behalf of a disabled child, they might be able to do that, but there's no surety that they would be able to. Parents care greatly about their children, and this really is a tragic situation, and everything, I'm reassured by many of the answers that the Minister has given, and I do hope that everything will work out and access will be readily available.
I can assure the noble lady that there is no way that those children will